And all of this is taking place from an EU perspective as part of the, I don't know if broader, but fundamental question of the relationship between the EU legal order and within it, the special place that measures have, and the world of international arbitration, commercial arbitration and investor state. How would you characterize that relationship today? What are the main hallmarks, or how would you describe that relationship between EU sanctions and international arbitration, if it's a fair question?
Hmm. Well, I think it's good that you separate commercial and investment treaty arbitration. Perhaps let's start with commercial, because I think that's what probably most people are interested in. Let's say that EU law has had an easier relationship with commercial arbitration than it has had with investment treaty arbitration. And a lot of the case law that deals with this matter historically was about things like competition law. But in more recent years, it is about sports arbitration and to what extent EU law should tolerate a system of referral of disputes to arbitration, which is systematic potentially, and therefore results in the fact that certain EU law, core EU law issues like claims, for breach of rights under the fundamental freedoms or the core of the internal market and competition law would be heard exclusively by an arbitral body sitting in Switzerland, the Court of Arbitration for Sport, and then by the Swiss Federal Tribunal. And all of that debate essentially led to a recent judgment of the European Court saying, well, insofar as the referral to arbitration is not systematic and it's not compulsory, so there is like genuine consent, voluntary submission to arbitration from both sides, then all we care about is essentially that the courts do a proper review of the awards for public policy violations. And insofar that happens, that's fine. I think the sanctions case, the recent sanction case that is before the European Court of Justice, we don't know how it will play out because the judgment is still pending. But it begs the question as to whether those pronouncements about commercial or non-state investor-state arbitration, which were delivered in the context of sports disputes, would also apply in a commercial context affected by sanctions. And that's, as I said before, the Commission came and said, actually, well, the arbitration can be a way of circumventing sanctions, and therefore the matter should be non-arbitrable.